Good evening to all.
A very good evening, all the participants. Today, we'll have a look at the various case laws. Uh, Although we are covering case laws as per new syllabus, but most of the case laws are included in old syllabus also. So there is some addition actually. 60 case laws were there earlier, and now there are 72 case laws. Weightage remains same. I hope my screen is visible. Is it visible?
Visible, sir.
Okay. So the first case is Innovative Industries versus ICICI Bank. And I have already shared this PPT today also in the group. I hope you have got it. So Innovative Industries, and I'll share it again on Innovative Industries versus ICICI Bank. So this was the case on section 7 basically. There were three issues. The first was that whether an application can be filed by the directors whose powers have been suspended. Another thing is that if there is a state legislation which contains provisions regarding moratorium, so whether and there is any inconsistency between the provisions which are contained in that state legislation and the central legislation, that is IBC, so which one will prevail? So these were some of the issues involved in this case. So application in this case was filed by ICICI Bank as a financial creditor of Innovative Industries Limited under section 7 because there was a default. Now, Innovative, they took two stands. First is, they said there was no debt legally due because an application can be filed only when there is a debt which is due and payable. So they said nothing is due because they said that this industries, Innovative Industries, it was located in Maharashtra. And they said we are covered by this Maharashtra Relief Undertakings Act. So Maharashtra Relief Undertakings Act provides relief to industries in cases there is any payment issues. And they say the moratorium would operate against such companies. It is basically a labor welfare legislation. The idea is that if the industries become sick, then it will result in unemployment. So this Maharashtra Relief Undertakings Act, which is basically a state legislation, it provides a moratorium initially for 1 year and then it can be extended for another year also. And they said since we are covered by this Maharashtra Relief Undertakings Act, so this this debt is no longer due and payable and there is no default as such. And second is they said that owing to non-release of funds under the Maharashtra Act, because the company went into some debt restructuring also, and the financial institutions, they were required to pay. And they said because certain funds were not released, so appellant was unable to pay back its debts as NVC. So these were the grounds which were taken by the Innovative Industries. Issues because this appeal was filed by the suspended directors. So the first issue was whether the appeal filed by the erstwhile directors on behalf of the company is maintainable once CIRP is there and insolvency resolution professional has been appointed to manage the company. And second is whether the appellant's vested right under the Maharashtra Relief Undertakings Act can be interfered with by the Insolvency and Bankruptcy Code. So these were the issues. Now, Supreme Court found substance in the plea taken on behalf of the ICICI Bank that the present appeal at the behest of the erstwhile directors is not maintainable. But Supreme Court said we are allowing it as a special case because this is the first application that has been moved under the court. And we consider it necessary to deliver a detailed judgment. So they allowed this aberration. They said that erstwhile directors cannot file an appeal. They cannot maintain an appeal on behalf of the company. But this was the first case. So Supreme Court made an exception for this case particularly. And the scheme of the code is to ensure that when a default takes place, in the sense that a debt becomes due and is not paid, the insolvency resolution process begins. when it comes to a financial creditor triggering the process, Section 7 becomes relevant. Under the explanation to Section 7.1, a default is in respect of a financial debt owed to any financial creditor of the corporate debtor. It need not be a debt owed to the applicant financial creditor. The issue of repugnancy also came because there was a repugnancy between state legislation, Maharashtra Relief Undertakings Act, and IBC. So they say repugnancy means the direct collision with each other, reaching a situation where it is impossible to obey the one without disobeying the other. So this happens when two enactments produce different legal results when applied to the same facts. So they said that whenever there is any repugnancy between a state act and a central act will prevail. And wherever there is any repugnancy between a earlier legislation and later legislation, then later legislation will prevail. The Supreme Court then examined Maharashtra Act and Insolvency and Bankruptcy Code and noted as follows. So they said Maharashtra Act is given in list 3. Okay? And this IBC is in list 2. So basically they said that appeal can be allowed. A Section 7 application is maintainable. And the Maharashtra Relief Undertakings Act, which is a state legislation, it has to give way to IBC, which is a central legislation by virtue of Section 238. 238 contains a non-obstante clause which says that, okay, whenever there is any issue between a central and a state legislation, then overriding effect of IBC will be there. So this was the judgment. Section 30.
Sir, excuse me, sir. Sir, is there what is the difference between being in list 2 in the parliamentary law and list
Actually,
3?
there are 3 lists. Actually, there are 3 lists. List 1, list 2,
sir.
list 3. So, first is the central list, the concurrent list, then central list and state legislations. So, 3 pieces of legislations are there and they are accordingly included in these 3 types of lists.
Right, sir.
So list 3 basically
central legislation, sir.
List 3 contains the matters on which state can legislate.
Achha.
List 2 contains provisions where the central can legislate. And list 1 is concurrent list on which both central and state can make legislation. So these are the 3 lists.
List 1 concurrent, list 2 is central list, list 3 state list.
हाँ, मुझे तो ऐसा ही ध्यान है, आप एक बार चेक कर लीजिएगा फिर भी इस पॉइंट
करेंगे. यस सर, यस सर,
है ना, ये वाला पॉइंट चेक कर लीजिएगा.
यस सर.
लिस्ट 1 है यूनियन लिस्ट. ठीक है, लिस्ट 1 यूनियन लिस्ट है, इसमें एक्सक्लूसिव है, ओनली द पार्लियामेंट कैन मेक लॉज हियर. लिस्ट 2 आपकी स्टेट लिस्ट है और लिस्ट 3 जो है वो
कॉन्करेंट लिस्ट.
हाँ, ये है.
अच्छा, यूनियन, स्टेट लिस्ट एंड कॉन्करेंट लिस्ट.
यस यस. हाँ, लिस्ट 3 ऑन विच बोथ कैन लेजिस्लेट, ये है. तो यू कैन पोस्ट दिस थिंग इन द ग्रुप ऑल्सो बिकॉज इट विल बी रेलेवेंट फॉर कॉन्स्टिट्यूशन पेपर ऑल्सो.
यस सर.
है ना. ठीक है.
यस सर, यस सर.
चलिए, ये हो गया हमारा. Now, second case is Mobilox Innovations versus Kirusa Software. So, this is basically a case law on Section 9. Because Section 9 says if there is a dispute, then the application cannot be admitted under IBC. So, this appellant Mobilox, it was engaged by Star TV for conducting televoting Nach Baliye program on Star TV. Now this Mobilox, they subcontracted a part of the job to Kirusa Software for providing various services relating to the TV program. So the respondent was to provide toll-free telephone numbers and there was a non-disclosure agreement also between the 2 parties, and Mobilox instructed Kirusa Software not to disclose this thing to the outside world. But what Kirusa said, But Kirusa, they disclosed on their web page that they had worked for the Nach Valley program run by Star TV, and thus there was a breach of the non-disclosure agreement. Okay? Because Mobilox was the main party engaged by Star TV, and they offloaded some part of the job to Kirusa Software, but they entered into a non-disclosure agreement with them that, okay, you will not disclose to the outside world that you are also working for this Nach Valley program. But they breached this non-disclosure agreement. So now the question came whether this breach of non-disclosure agreement, whether it can constitute a dispute. This was the issue involved basically. And when a bill was raised by this Kirusa Software, Mobilox Innovations refused to pay on the ground that you have breached the non-disclosure agreement and we are not going to pay you. So one of the issue which came before Supreme Court was regarding Section 5, subsection 6. Because Section 5, subsection 6, if we see, it has the definition of dispute. So what it says, Section 5, subsection 6 says, dispute includes a suit or arbitration proceedings relating to existence of the amount of debt, quality of goods or services, or the breach of a representation or warranty. So now, what was sought to be brought as a defense was that the non-disclosure agreement was breached and it would not come within the definition of dispute. So this was one of the issues, whether breach of a non-disclosure agreement comes within the definition of dispute, which is given in Section 5, subsection 6. Now what Supreme Court said? Supreme Court said the existence of the dispute and or the suit or arbitration proceedings must be pre-existing. That is, must exist before the receipt of the demand notice or the invoice, as the case may be. And now if we read, so we have to read Section 5, subsection 6, and then we have to read Section 8 also. Section 8, subsection 2A. What it says? 8.2A says, existence of a dispute, if any, or record of the pendency of the suit or arbitration proceedings filed before the receipt of such notice or invoice in relation to such dispute. So now they said the word and occurring in Section 8.2A must be read as or. Actually, earlier, prior to this 2018, the word was and, but now it has been replaced by the word or. So this was the case before that. So they said the word and occurring in Section 8.2A must be read as or, keeping in mind the legislative intent and the fact that an anomalous situation would arise if it is not read as or. If read as and, disputes would only stop of the bankruptcy process if they are already pending. So they said a dispute need not be pending, already pending. It could be existence of a dispute, if any, or record of dependency. So there could be a dispute even though there is no suit or there is no arbitration proceeding pending. And now the word and has been replaced by or after this judgment. So in this case, the main thing was Supreme Court also agreed that a dispute exists in this case. And because dispute exists, so Section 9 application cannot be filed. Third case, State Bank of India versus V. Ramakrishnan and another. Here the issue is whether this Section 14, which provides for a moratorium for limited period mentioned in code on admission of an insolvency petition, would not apply to a personal guarantor of a corporate debtor. So I think it pertains to the new syllabus, but still it is relevant for the understanding of Section 14. So this respondent number 1, Mr. Ramakrishnan, he was the managing director of the CD, namely respondent number 2 company, and also the personal guarantor. So now the issue is, suppose insolvency proceedings have been initiated against the company. Now, whether Section 14 would operate against the director also, this is the issue. Here the company did not pay and the account of company was declared as NPA. Notice was issued under SARFAESI and then possession notice under 13(4). But in the meantime, company filed a petition. This because company itself can also file a petition under section 10 to initiate the CIRP process. And it was admitted also, followed by the moratorium that was imposed statutorily by section 14. So while the said proceedings were pending, an interim application was filed by the respondent number 1 as personal guarantor to the corporate debtor, in which respondent number 1 took up the plea that section 14 of the code would apply to personal guarantor as well. So he said, I am being a guarantor, I am also covered by section 14. So this was the plea which was taken by Ramakrishnan. Okay. As a result of which proceedings against the personal guarantor and his property would have to be stayed. NCLT held that since section 31, a resolution plan would bind the personal guarantor as well, and since after the creditor is proceeded against the guarantor stands into the shoes of the creditor, section 14 would apply in favor of the personal guarantor as well. Okay. So they allowed this application. So Supreme Court said that Part 3 has not yet been brought in force. Part 3, as we know, it is not yet notified. The rules and regulations are not there except in case of personal guarantors to corporate debtors. Part 3, we all know, deals with individuals and partnership. Part 2 deals with corporates. There are 5 parts. Part 1 general, then Part 2 corporate persons, Part 3 individuals, and then Part 4 and Part 5. Part 5 is miscellaneous and Part 4 deals with the regulatory aspects of IBBI, IPA, etc. This we all know. So the first important thing that needs to be noticed is that Part 3 of the code has not yet been brought in force. This part is entitled Insolvency Resolution and Bankruptcy for Individuals and Partnership Firms. The repealing provisions, namely Section 243, it has also not been brought into force. Section 249, this is also not yet notified. Under Part 2 of the code, which deals with insolvency resolution and liquidation for corporate persons, a financial creditor or a corporate debtor may make an application to initiate this process. So once initiated, the adjudicating authority, after admission, shall by order declare moratorium. So section 14, they said, refers to 4 matters. So we can open side by side section 14 also. So if we see section 14, that deals with 4 types of issues. First is institution or continuation of proceedings. Second is transferring, encumbering or alienating of assets. Third is any action to recover security interest or recovery of property by an owner. So these are the 4 things which are covered by section 14. So indeed, the corporate, but what is conspicuous by its absence is any mention of the personal guarantor. So all these sections are, all these provisions are as against the corporate debtor. A plain reading of the said section therefore leads to the conclusion that the moratorium referred to in section 14 can have no manner of application to personal guarantors of a corporate debtor. Now, they referred to section 2 subsection E also. And if we see section 2E, so section 2E, what it says? Section 2E says it applies to personal guarantors to corporate debtor also. And section 60, they are strongly relied upon by the counsel for the respondents, as according to them, the code will apply to personal guarantors of the corporate debtors. And by section 60, proceedings against such personal guarantors will show that such moratorium extends to the guarantor as well. So they said section 60 refers to proceedings, and because proceedings are stayed by virtue of section 14, so section 14 will apply to us. But Supreme Court did not entertain this argument, and they said that it would not apply to a personal guarantor. Next case is Pioneer Urban Land and Infrastructure Limited versus Union of India. देखिए इसमें मेन बात क्या है, जितने भी केस लॉ हम पढ़ रहे हैं, there are 2 ways of reading these case laws. One is that you can read the entire case law. So what you can do is you can just यहाँ से कॉपी पेस्ट कर लीजिए. जैसे ये है, ये आपका देखिए, ये पर्सनल गारंटर आपने लिखा, यहाँ से इसको आपने कॉपी पेस्ट करके आप इसको गूगल में करिए, तो आपको क्या मिलेगा, आपको ना एक उसका लिंक मिल जाएगा, indianqanun.org, कंट्रोल V. सो indianqanun.org जो है, वहां पर क्या है, आपको पूरे का पूरा केस लॉ मिल जाएगा, एंटायर केस लॉ. सो व्हाट यू कैन डू इज, यू कैन जस्ट कॉपी ये वाला ऊपर में जो ब्राउजर में लिंक दिया हुआ ना, कंट्रोल सी, ये कंट्रोल सी करके, और इसको आप वहां पर कॉपी कर लीजिए, बस इतना कर लीजिए. उससे क्या होगा, इफ यू वांट टू रीड इट यू कैन रीड, बस. ठीक है, इस तरह से कर लीजिए इफ यू आर इंटरेस्टेड इन रीडिंग. नाउ इट इज योर ओन डिस्क्रिप्शन. देखिए 5 मार्क्स का है इसमें कवरेज. फॉर 5 मार्क्स हमने आपको कितना 196 स्लाइड्स तो हमने दे दिया, कम से कम इतना तो आपको पढ़ ही लेना है. इसके अलावा इफ यू वांट टू गो बियॉन्ड दैट, तो आप इसमें ये कर सकते हैं. एंड आई हैव क्रिएटेड सम ऑनलाइन टेस्ट आल्सो फॉर दिस. आई थिंक सम ऑफ यू माइट हैव ऑलरेडी अटेम्प्टेड इट, नहीं तो आप अटेम्प्ट कर लीजिएगा. तो आप, इट इज अप टू यू कि कितना टाइम आपके डिस्पोजल पर है, अकॉर्डिंगली यू कैन गो. ठीक है, इफ यू हैव टाइम you can discuss in, you can read in detail, है ना. For each case law you will find something like this. Now background, because this section 58F explanation was inserted at a later date in 58F. 58F क्या बोलता है, section 58F if we see, ये 58F कहता है, this explanation was inserted in 2018. So they said, for the purpose of this sub-clause, any amount raised from an allottee under a real estate project shall be deemed to be an amount having the commercial effect of a borrowing. Okay? And the expression allottee and real estate shall have the meaning as given in RERA. So this was the explanation inserted in 2018. When this IBC code came initially, this explanation was not there. So in some cases, the amendments which are brought at a later stage, they are challenged. So this case, they challenge the constitutional validity of certain provisions of IBC, particularly after the inclusion of home buyers as financial creditors. So section 58F, because it included amount raised from allottees under the real estate projects as financial debt. So this effectively gave home buyers the status of financial creditors, enabling them to initiate insolvency proceedings under section 7 of the IBC. Now, the issue before the Supreme Court was whether home buyers can be classified as financial creditors, whether 2018 amendment violated Article 14 and Article 19(1)(g. देखिए होता क्या है, बहुत सारे केसेस ना डायरेक्टली सुप्रीम कोर्ट में पहुंच जाते हैं. कोई जरूरी नहीं है कि एनसीएलटी में जाए फिर एनसीएलटी में जाए सुप्रीम कोर्ट, बिकॉज दे आर फाइल्ड बाय वे ऑफ रिट पिटिशंस. ठीक है, and as we know, our Constitution of India that allows us freedom to file writ petitions under Article 32 for violation of fundamental rights before Supreme Court and under Article 226 before High Court, है ना. तो ये जितने भी बहुत सारे ऐसे केसेस जो फाइल होते हैं, दे आर फाइल्ड बाय वे ऑफ रिट पिटिशंस. और वो उसमें क्या, वो एक पर्टिकुलर आर्टिकल का रेफरेंस देते हैं कि दिस आर्टिकल इज वायलेटेड. ठीक है, तो इसमें क्या कहा, वेदर द आईबीसी हैज अमेंडेड अंडरमाइन द राइट्स ऑफ रियल एस्टेट डेवलपर्स. So this amendment was challenged by real estate developers on the following grounds. Once, that amendment is discriminatory inasmuch as it treats unequals equally and equals unequally, having no intelligible differential. A good management which has several projects on its hand can be removed at the instance of one allottee and either replaced. Okay. The amendment made in spite of fact that there is a specific legislation available, namely RERA, which deals in detail with the real estate sector issue and provide for adjudication of disputes between allottees and developers. Now, please appreciate that when IBC came, the default amount was also 1 lakh only. ठीक है, अब 1 लाख का डिफॉल्ट अमाउंट था. एक होम बायर का भी डिफॉल्ट हो गया, सपोज वन होम बायर फील्स एग्रीव्ड, ही कुड हैव फाइल्ड द एप्लीकेशन. और पहले क्या था, सेक्शन 12 में भी नहीं था, विड्रॉल में नहीं था, है ना. तो वंस सीआईआरपी वाज एडमिटेड अगेंस्ट ए पर्टिकुलर कॉर्पोरेट, सो इट हैड टू अंडरगो द एंटायर प्रोसेस. तो रियल जो डेवलपर्स से उनको बड़ी प्रॉब्लम हो गई. डेवलपर्स ने कहा भाई यू हैव इंक्लूडेड होम बायर्स एज फाइनेंशियल क्रेडिटर्स एंड इवन इन सिंगल होम बायर ही कैन क्रिएट डिस्टर्बेंस. तो प्रॉब्लम यहां पर थी. ठीक है, क्योंकि जितने भी केस लॉ है हमारे को उस हिसाब से पढ़ना है, उसकी बैकग्राउंड को देखते हुए। आज की डेट में सिचुएशन डिफरेंट है, इसीलिए बाद में फिर दोबारा अमेंडमेंट किया होम बायर्स में, भाई सिंगल बायर कैन नॉट इनिशिएट दिस एप्लीकेशन। उन्होंने कहा मिनिमम 10% या 100, वो इसीलिए आया था decision. Apex Court observed that from the introduction of the explanation to section 58F of the code, it is clear that the parliament was aware of RERA. अब उन्होंने कहा जब 58F में एक्सप्लेनेशन लगाई है तो क्या है, उनको भी रेरा के बारे में पता है, क्योंकि रेरा का रेफरेंस दे दिया 58F में, है ना। सो यू कैन नॉट से दैट भाई रेमेडी इज अवेलेबल अंडर रेरा, तो यहां पर क्यों आ रहे हैं वो, and applied some of its definition provisions so that they could apply when the code is to be interpreted. The fact that RERA is in addition to and not in derogation of the provisions of any other law for the timing in force also makes it clear that the remedies under RERA to allottees were intended to be additional and not exclusive remedies. ठीक है, तो उन्होंने बोला कि रेरा की जो रेमेडीज है वो एडिशनल रेमेडीज है। Court also held that even by a process of harmonious construction, RERA and the code must be held to coexist. And in the event of a clash, RERA must give way to the, ठीक है, Apex Court has upheld the amendment. ये जो 58F वाली amendment थी, the Supreme Court upheld this amendment. So the significance of this judgment is that it has strengthened the rights of home buyers, recognized them as important stakeholders in real estate insolvency cases. It upheld the legislative intent, supported the government's move to provide home buyers legal recourse under the IBC, and clarity on RERA versus IBC was provided, and it was held that both can operate together, each having its own scope.
So, sir, which act has the upper hand actually?
नहीं, अपर हैंड बोल दिया ना, ले लिया ना, इन द इवेंट ऑफ ए क्लैश, अगर दोनों में क्लैश होगा तो रेरा मस्ट गिव वे टू द कोर्ट।
ओके,
लिख दिया ना, इसी जजमेंट में लिख दिया इन्होंने।
ओके,
ये लिखा ना, ये इसको भी मैं हाईलाइट कर देता हूँ।
so anyway the code is more powerful in
Article section 238 sir of IBC.
हाँ हाँ, नेक्स्ट केस देखते हैं, आर्सलर मित्तल इंडिया प्राइवेट लिमिटेड वर्सेस सतीश कुमार गुप्ता। देखो ऐसा है, आज की डिस्कशन का पर्पज ये है कि यू विल गेट एन ओवरव्यू, है ना, थोड़ा सा इट विल हेल्प यू इन बेटर अंडरस्टैंडिंग ऑफ द कोड ऑल्सो। और ये है कि इसके बाद में फिर आप और डिटेल में अगर पढ़ना चाहें तो फिर indianqanun.org पे यू कैन सर्च फॉर द पर्टिकुलर केस लॉ एंड यू कैन रीड द एंटायर जजमेंट। बट इतना तो कम से कम पढ़ ही लेना चाहिए आपको, जितना यहाँ पर हमने दिया हुआ है, ठीक है। The facts of the present case revolve around the ineligibility of resolution applicants to submit resolution plans after the introduction of section 29A. ठीक है, in this case NCLT they admitted an application under section 7, ठीक है, and there were two resolution applicants, ArcelorMittal India Private Limited and New Metal, but both were found ineligible because they said regarding ArcelorMittal, the AM Netherlands BV was declared as connected person in AM IPL resolution plan. AM Netherlands BV has acquired 29% equity in Uttam Galva and has entered into a co-promoter agreement with other promoters of Uttam Galva. Uttam Galva account was classified as NPA. ठीक है, क्योंकि connected person भी है in 29A we have read that even if a connected person is having an NPA account, then the resolution applicant will be ineligible. ठीक है, so the first thing that was argued at which parties were at loggerheads was the time at which subclause C can be set to operate. अब इन्होंने बोला जो 29A है ये ऑपरेट कब करेगी, ठीक है, एट द टाइम ऑफ एडमिशन ऑफ एप्लीकेशन और एट द टाइम ऑफ सबमिशन ऑफ रेजोल्यूशन प्लान, ठीक है। अकॉर्डिंग टू श्री रोहतगी, in the original subclause, pre-amendment time must necessarily be date of CIRP. इन्होंने कहा भाई date of CIRP को देखनी चाहिए आपको ये। According to Mr. Salve and Singhvi, it is clear that since submission of a resolution plan is spoken of, it is time of submission of such plan. ठीक है, तो उन्होंने कहा ये जो इनएलिजिबिलिटी आपको देखनी है ये देखनी है एट द टाइम ऑफ सबमिशन ऑफ रेजोल्यूशन, ठीक है। द कोर्ट हेल्ड, सुप्रीम कोर्ट ने कहा कि ओपनिंग वर्ड्स ऑफ सेक्शन 29A furnish a clue as to the time at which subclause C is to operate. तो ओपनिंग वर्ड्स ऑफ सेक्शन 29 क्या लिखा है? ए पर्सन शेल नॉट बी एलिजिबल टू सबमिट ए रेजोल्यूशन प्लान. So it is clear, therefore, that the stage of ineligibility attaches when the resolution plan is submitted by a resolution applicant. The contrary view expressed by Shri Rohtgi is obviously incorrect, as the date of commencement of the corporate insolvency date कर देता हूँ उसको. Date of commencement of the CIRP is only relevant for the purpose of calculating whether 1 year has lapsed from the date of classification of the person as NPA. ठीक है. Further, the expression used is has, which, as Dr. Singhvi has correctly argued, is in present tense. So this is to be contrasted with the expression has been, which is used in sub clauses D and G. अब देखो, एक एक वर्ड के ऊपर एम्फेसिस है. जैसे 29 है, यू कैन ओपन 29 है ऑल्सो. और 29 में देखिए क्या लिखा है.
Person shall not be eligible to submit a plan
हाँ,
if such
है ना.
person is a
लेकिन
person.
अगर आप पॉइंट नंबर ये देखिए डी और जी, डी में क्या लिखा है? हैज बीन. तो ये पुरानी बात है. ये एट द टाइम ऑफ सबमिशन नहीं देखना. ये कन्विक्शन कब होगा? ये पिछले 2 साल में होगा. पुराना है ना. डी और जी जो क्लॉज है, जैसे जी क्या बोलता है? हैज बीन ए प्रोमोटर. ठीक है ना. तो वो ये कह रहा है कि डी और जी में जो है वो पिछली डेट की बात कर रहा है, और यहां पर बात कर रहा है एट द टाइम ऑफ सबमिशन. यहां CIRP डेट पे नहीं जाना आपने. A resolution applicant has no vested right and his resolution plan to be considered. It is clear that no challenge can be preferred to adjudicating authority at CIRP stage. अब वो ये कहता है कि जो रेजोल्यूशन एप्लीकेंट है उसका कोई वेस्टेड राइट नहीं है, ठीक है, कि भाई उसका रेजोल्यूशन प्लान हम जरूरी कंसिडर करें. The RP is not required to take any decision, but merely to ensure that the resolution plans submitted are complete in all respect before they are placed before COC, who may or may not approve it. Section 32E does not empower the RP to decide whether the RP does or does not contravene the provisions of laws. ठीक है. लेकिन इसमें the Supreme Court they exercise their powers which are given in Article 142. आर्टिकल 142 क्या बोलता है? आर्टिकल 142 BC वो पावर देता है सुप्रीम कोर्ट को कि इन द इंटरेस्ट ऑफ जस्टिस यू कैन टेक एनी डिसीजन. जरूरी नहीं कि वो लॉ में लिखा ही हो. ठीक है ना. अगर हम आर्टिकल 142 पढ़े तो आर्टिकल 142 क्या बोलता है? Article 142 grants the Supreme Court the power to pass decree or make orders necessary for doing complete justice in any case or matters pending before it. This power can be used to secure the attendance of a person, order the discovery or production of documents, or investigate and punish contempt of court. ठीक है. तो it allows the Supreme Court to take action outside the traditional confines of legal proceedings to ensure a just outcome. ठीक है. Basically to do complete justice. भाई बहुत सारी बातें लॉ में भी नहीं लिखी हैं, तो फिर आर्टिकल 142 में सुप्रीम कोर्ट के पास पावर है. ठीक है. ये भी मैं यहां पर डाल देता हूं उसको. ये हम ये देखो, ये सारा ना आपके पास वो एडिटेबल है. आप कहीं भी इंसर्ट करके कुछ भी डाल सकते हैं अपने हिसाब से. हाईलाइट कर लीजिएगा, कुछ भी कर लीजिए. तो इन्होंने क्या कहा? आर्टिकल 142 में सुप्रीम कोर्ट एक्सरसाइज इट्स पावर्स, और उन्होंने बोला भाई एक और अपॉर्चुनिटी दे दो इनको. ठीक है, कि भाई विद इन 2 वीक्स ऑफ द सुप्रीम कोर्ट जजमेंट ये एनपीए का पेमेंट कर दो, और फिर जो है अपना ये रेजोल्यूशन एप्लीकेंट्स बन सकते हैं. ठीक है. अगर अभी भी आप देखोगे तो वहां पर भी 30 डेज का टाइम अलाउ करते हैं. नाउ अगर आप सेक्शन 30 एक बार देखिए. सेक्शन 30 इफ यू सी, सेक्शन 30 में सब सेक्शन 4 के नीचे फर्स्ट, सेकेंड, Second proviso, provided further that where the resolution applicant referred to in the first proviso is ineligible under clause C of 29A, the resolution applicant shall be allowed by the COC such period not exceeding 30 days to make payment of overdue amounts in accordance with the proviso to clause C of section 29. ठीक है, ये बात अभी भी सेक्शन 30 में भी लिखी हुई है, सेक्शन 30 सब सेक्शन 4 सेकंड प्रोवाइजो. ठीक है, तो ये केस इसमें इन्होंने कहा कि भाई ठीक है, हम एक बार इनको और अपॉर्चुनिटी देते हैं कि भाई आप पेमेंट कर दो और बन जाओ रेजोल्यूशन एप्लीकेंट. ये आर्टिकल 142 भी मैंने इसके अंदर डाल दिया. ठीक है, चलिए 6 कमिटी ऑफ क्रेडिटर्स. एक मिनट, ये जो है ये जो बात है, ये वाली बात मैं इसके अंदर डाल देता हूँ. ये 1 2 3 वाली जो लिस्ट वाली बात है ना, इसको भी साथ के साथ कर दो. ये हमारी पहली वाली जजमेंट थी ना इसकी. हम्म, ठीक है जी. ये यूनियन लिस्ट, स्टेट लिस्ट और कंकरेंट लिस्ट. चलिए ये भी. अब चलते हैं नेक्स्ट केस लॉ पर. नेक्स्ट केस लॉ था हमारा ये कमेटी ऑफ क्रेडिटर्स ऑफ एसआर स्टील लिमिटेड वर्सेस सतीश कुमार गुप्ता. ये भी बहुत बढ़िया जजमेंट है. इसमें क्या हुआ, the group appeals and writ petitions raised important questions as to the rule of RP, RA, COC that are constituted under the IBC. बहुत सारी चीजों को चैलेंज किया गया. ठीक है, तो इसमें पहला क्वेश्चन ये था कि व्हाट इज द रोल ऑफ आरपी, व्हाट इज द रोल ऑफ पीआरए, व्हाट इज द रोल ऑफ सीओसी, whether the power of judicial review of the decision by the adjudicating authority and appellate tribunal is limited, whether equitable principles can be applied. ये बहुत सारे क्वेश्चंस थे इस केस. ठीक है, तो सबसे पहले रोल ऑफ आरपी के बारे में सुप्रीम कोर्ट ने क्या कहा. सुप्रीम कोर्ट सेड द कोर्ट कंक्लूडेड दैट द रेजोल्यूशन प्रोफेशनल इज ए पर्सन who is not only to manage the affairs of the corporate debtor as a going concern from the stage of admission till a resolution plan is approved. He is also a key person who is to appoint and convene meetings of the COC that they may decide upon the resolution plans. ठीक है, and another very important function of the RP is to collate and finally admit claims of all the creditors which must then be examined for payment. ठीक है, तो ये रोल ऑफ आरपी की बात की. रोल ऑफ पीआरए क्या, प्रोस्पेक्टिव रेजोल्यूशन एप्लीकेंट. So the Supreme Court referred UNCITRAL legislative guide and provisions of CIRP regulations to determine the role of prospective resolution applicant. Now, Supreme Court said that the prospective resolution applicant has a right to receive complete information as to the corporate debtor, debts owed by it, and its activities as a going concern prior to the admission of an application under Section 7, 9, and 10 of the Code. For this purpose, it has a right to receive information contained in the information memorandum as well as the evaluation matrix. Role of COC. Regarding role of COC, they said it is the commercial wisdom of the COC that is to decide on whether or not to rehabilitate the CD by means of acceptance of a particular resolution plan. ठीक है, it is clear that since corporate resolution is ultimately in the hands of majority vote of the COC, nothing can be done qua the management of the corporate debtor by the RP, which impacts major decisions to be made in the interregnum between the taking over of the management and the corporate resolution. What is left to the majority decision of the COC is the feasibility and viability of a resolution plan, which obviously takes into account all aspects of the plan, including the manner of distribution of funds among the various classes of creditors. What is important is that it is the commercial wisdom of this majority of creditors, which is to determine through negotiation with the prospective resolution applicant as to how and in what manner the corporate resolution process is to take place. Now, regarding the jurisdiction of NCLT and NCLT. So they said there is no doubt whatsoever that the ultimate discretion of what to pay and how much to pay to each class or subclass of creditors is with the COC. But the decision of the COC must reflect the fact that it has taken into account maximizing the value of the assets of the corporate debtor and the fact that it has adequately balanced the interest of all stakeholders, including operational creditors. अगर आप सेक्शन 30 में देखो, सेक्शन 30 देखोगे तो आपको ये बात क्लियरली लिखी हुई नजर आएगी. सेक्शन 30 में ये बात लिखी हुई है. सेक्शन 30 में क्या लिखा है? सेक्शन 30 अगर आप पढ़ोगे तो सेक्शन 30 में बात क्लियर लिखी. Good. Now, so there is regarding jurisdiction of NCLT and NCLT, there is no doubt whatsoever that the ultimate discretion of what to pay and how much to pay each class or subclass of creditors is with the COC. But the decision of the COC must reflect the fact that it has taken into account maximizing the value of the assets of the corporate debtor and the fact that it has adequately balanced the interest of all stakeholders, including operational creditors. ठीक है. This being the case, judicial review. अब जुडिशियल रिव्यू एडजुडिकेटिंग अथॉरिटी क्या कर सकती है ना. इन्होंने कहा देखो भाई सीओसी की कमर्शियल विजडम तो सुप्रीम है, तो एडजुडिकेटिंग अथॉरिटी का पास क्या स्कोप रह गया that the resolution plan as approved by the COC has met the requirements referred to in section 30 subsection 2 would include judicial review that is mentioned in section 30 subsection 2E as the provisions of the code are also the provisions of law for the timing in force. अगर हम सेक्शन 30 सबसेक्शन 2 सबसेक्शन ई पढ़े तो क्या बोलता है? Does not contravene any of the provisions of the law for the timing in force and conforms to such other requirements. ये है सेक्शन 30 सबसेक्शन 2 सबसेक्शन ई. Now regarding whether equality principle can be applied among secured and unsecured creditors. उन्होंने बोला क्या इक्वल होना चाहिए? उन्होंने कहा इक्वल कोई जरूरी नहीं है, इट शुड बी इक्विटेबल. ठीक है. Whether committee of creditors can constitute a subcommittee, Supreme Court said yes, a subcommittee may be formed but for administrative purposes only and the ultimate responsibility will be of the COC only. ठीक है. Next point which was considered was whether the plan can provide for extinguishment of rights of personal guarantors. क्योंकि होता क्या है, suppose personal guarantor has paid money, ठीक है, on behalf of the CD. So whether it will step into the shoes of the CD, है ना, whether such a term is binding. So they said the resolution plan is equally binding on the personal guarantors also and the claims of guarantors shall stand extinguished. नेक्स्ट पॉइंट आता है बीके एजुकेशनल सर्विसेज प्राइवेट लिमिटेड वर्सेस पराग गुप्ता एंड एसोसिएट्स. ये केस क्या था? इसमें ये था बेसिकली इट इज ऑन लिमिटेशन पीरियड. सो दिस केस एड्रेस द क्रूशियल इश्यू ऑफ लिमिटेशन पीरियड. लिमिटेशन पीरियड के बारे में 2-3 बातें हैं. सबसे पहला कि नॉर्मली द लिमिटेशन पीरियड इज 3 years फ्रॉम द कॉज ऑफ एक्शन. ठीक है. एंड देयर इज ए प्रोविजन in section 5 of limitation act which says that a delay, if it is established by way of sufficient cause, so delay can be condoned also, है ना. तो बेसिकली इतनी 2 बातें तो हमारे को ध्यान में रखनी है. और तीसरी बात ये कि दिस applies to IBC also. So this case addressed the crucial issue of limitation period under the IBC, specifically for applications filed under Section 7 and Section 9. At the time, there was ambiguity as to whether the Limitation Act applied to IBC proceedings, since the IBC did not initially mention it explicitly. जब IBC आया था तो उस टाइम ये स्पेसिफिकली मेंशन नहीं था कि भाई लिमिटेशन एक्ट लगेगा या नहीं लगेगा. इन्होंने बाद में क्या किया, बाद में इन्होंने 238A इंट्रोड्यूस किया. 238A बोलता है तब, और 238A आपका आया था 2018 में, है ना. आईबीसी तो 2016 में आ गया था. द प्रोविजंस ऑफ द लिमिटेशन एक्ट shall as far as may be apply to the proceedings or appeals before the adjudicating authority before NCLAT, DRT as the case may be. ठीक है, तो adjudicating authority, NCLAT और DRT पर भी ये लगेंगे. ये 238A आ गया हमारा अपना 2018 में. So present appeal was filed against the final judgment and order dated 7th of November 2017 passed by the NCLAT New Delhi in company appeal, whereby the NCLAT has held that the provisions of the Limitation Act are not applicable for initiation of CIRP. क्योंकि जब आईबीसी इनिशियली आया था ना तो लिमिटेशन एक्ट के बारे में लिखा तो था नहीं. बहुत सारे लोगों का ये इंटरप्रिटेशन था कि भाई जब से आईबीसी आया है तब से 3 साल काउंट होंगे, तब से काउंट नहीं होंगे, जब से डिफॉल्ट हुआ तब से काउंट होंगे. अगर मान लो, क्योंकि इसमें पुराने केसेस भी आ गए थे आईबीसी में, है ना, जो दूसरे फोरम्स पर चल रहे थे. सपोज आपका डिफॉल्ट हुआ 2010 में, तो क्या आप 2016 आने के बाद में वो फिर 3 साल मिल जाएंगे? द आंसर इज नो, है ना. So issues were whether an application under Section 7 of the code can be filed before A in respect of debt which is barred by Limitation Act. ठीक है, whether Section 5 of the Limitation Act is applicable to CIRP and whether Section 238A as introduced by the Second Amendment Act operates retrospectively. ठीक है, तो ये these were the issues. So Supreme Court held that the code cannot be triggered in the year 2017 for a debt which was time barred say in 1990. ठीक है, एक डेट 90 में टाइम बार्ड हो गया था, तो क्या उसके लिए भी चल जाएगा? ये नहीं, as that would lead to the absurd and extreme consequence of the code being triggered by a stale or dead claim, leading to drastic consequence of instant removal of the present board of directors of the CIRP of the CD permanently, and which may ultimately lead to liquidation and therefore corporate death. This being the case, the expression debt due in the definition sections of the code would obviously only refer to debts that are due and payable in law, that is the debts that are not time bound. Supreme Court have held that at least insofar as the code is concerned, the intention of the legislature from the very beginning was to apply the Limitation Act to the NCLT and the NCLAT while deciding applications filed under Section 7 and 9 of the code and appeals therefore. तो वो ये कह रहा है कि भाई इंटेंशन शुरू से ही ऐसी थी. हमने बाय वे ऑफ क्लैरिफिकेशन ये अमेंडमेंट लाया है 238A का, ये नहीं कि ये 238A अगर 2018 में आया तो तब से नहीं, शुरू से ही. Section 433 of the Companies Act, which applies to the tribunal and the appellate tribunal, expressly applies the Limitation Act to the appellate tribunal as well. ठीक है. So this judgment laid down a clear precedent that IBC proceedings are governed by the Limitation Act, ensuring that only legally enforceable, that is not time-barred debts can be the subject of CIRP. So it prevented misuse of the IBC for reviving old or dead claims. Next case था चित्रा शर्मा and others versus Union of India. इस केस में क्या था कि IDBI Bank they instituted a petition under Section 7 against JP Infratech before the NCLT Allahabad branch. ठीक है, IDBI Bank claimed that GIL had committed a default of 526.11 crores in the repayment of its dues. ठीक है, NCLT initiated CIRP, moratorium was issued, ठीक है, and continuation of pending proceedings including execution proceedings was prohibited. IRP was appointed and invited claims. There was an amendment to the regulations and they said that home buyers, they could fill in form F as they could not be treated as par with financial and operational creditors. देखो पहले क्या था, there was confusion when IBC came कि home buyers के बारे में confusion था. होम बायर्स के बारे में कहते थे भाई ना तो ये फाइनेंशियल क्रेडिटर है ना ये ऑपरेशनल. फाइनेंशियल क्रेडिटर इसलिए लोन तो दिया नहीं कंपनी को, ना ये ऑपरेशनल क्रेडिटर है. तो इनको अदर क्रेडिटर्स के बारे में कहते थे, भाई आप फॉर्म F भर लो, ठीक है। अब ये जो पिटिशन फाइल किया था चित्रा शर्मा ने, so the main grievance for filing the instant petition was that CIRP ignores the interests of vital stakeholders in building projects. इन्होंने बोला देखो भाई ऐसा है, ये जो पैसे लगाते हैं ये तो होम बायर्स लगाते हैं प्रोजेक्ट में, है ना, chief among whom are individuals who have invested their wealth in pursuit of the human desire to own a home. The IBC in the submission of the petitioners recognized only three categories of or classes: corporate debtor, financial creditor, or operational creditors. Not being protected by the IBC, the petitioners contended that the rights conferred upon them by special enactments, including Consumer Protection Act and by RERA, could not be divested. Suspension of the right to seek redressal before an adjudicatory forum under Section 14(1)(a) would, it was asserted, leave the home buyers without a remedy. Section 238 of the IBC gives it an overriding effect over other laws in existence. अब इस केस में हुआ क्या था, CIRP ऑलरेडी कंक्लूड हो चुकी थी, 270 डेज जा चुके थे, ठीक है। होम बायर्स डिड नॉट हैव द स्टेटस ऑफ फाइनेंशियल क्रेडिटर्स। अब ये देखो ये बात है जब होम बायर्स को इन्होंने फाइनेंशियल क्रेडिटर नहीं माना था, तब के पीरियड की बात है, तब का पीरियड का केस है ये, ठीक है। सो दे हैड नो स्टैट्यूटरी वोटिंग राइट्स इन द COC. Under the interim directions of this court, a workable arrangement was sought to be put into place by appointing representatives of the home buyers into COC to facilitate their interest being duly borne in mind. But the point to be noted is that in the absence of statutory recognition of the position of home buyers as financial creditors, the law did not allow for real and substantive entitlements to them in the COC. भाई रिप्रेजेंटेटिव तो आ गए COC में, लेकिन उनके पास वोटिंग पावर वगैरह तो नहीं आई ना। These statutory entitlements have been brought in by the ordinance. फिर एक ऑर्डिनेंस लाए कि भाई इनको जो है एज फाइनेंशियल क्रेडिटर आप रिकॉग्नाइज करो, इन ऑर्डर टू रिकॉग्नाइज द वाइटल इंटरेस्ट ऑफ द होम बायर्स इन ए रियल एस्टेट प्रोजेक्ट एंड टू अलाउ देम ए स्टैट्यूटरी स्टेटस इन द CIRP प्रोसेस, ठीक है। तब तक क्या हुआ था, जब तक ये ऑर्डिनेंस आया द पीरियड ऑफ 270 डेज had expired, ठीक है। And IRP informed the NCLT that no resolution plan had been approved. So peculiar situation has arisen as a result of which the status of the home buyers, which had not been recognized prior to 6/6/2018, has now been expressly recognized as a result of the amending ordinance. अब ordinance आ गया था। अब इन्होंने ये कहा, सुप्रीम कोर्ट ने ये कहा कि भाई ऐसा है कि अब आप दोबारा CIRP शुरू कर दो, ठीक है। The Supreme Court felt that in the facts of the present case, recourse to the power under Article 142 would be warranted to render complete justice, ठीक है। The power under Article 142 should be utilized at the present stage for the limited purpose of recommencing the resolution process afresh from the stage of appointment of the IRP by the order dated 9/8/2017 and resultantly renew the period which has been prescribed for the completion of the resolution process. तो उन्होंने कहा दोबारा CIRP शुरू कर। नेक्स्ट केस है हमारा अनुज जैन। तो आर्टिकल 142 भी एक इंपॉर्टेंट आर्टिकल है और इसके बारे में भी आप थोड़ा सा पढ़ लेना जरूर। अनुज जैन IRP फॉर JP Infratech वर्सेस एक्सिस बैंक एंड अदर्स। ये वाला केस हमने पहले भी डिस्कस किया था जब हमने 4143 डिस्कस किया था, है ना। दिस केस इज रिलेटेड टू PUFE ट्रांजेक्शंस। JP Infratech के पास लैंड बैंक है, लेंडर्स ऑफ जयप्रकाश एसोसिएट्स लिमिटेड है, जयप्रकाश एसोसिएट्स लिमिटेड इज द होल्डिंग कंपनी, और लेंडर्स ऑफ जयप्रकाश एसोसिएट्स लिमिटेड इनको क्या मॉर्टगेज कर दी लैंड, किसने, JP Infratech की जो लैंड थी। तो जो जयप्रकाश एसोसिएट्स के लेंडर्स थे उन्होंने कहा कि वी शुड बी इंक्लूडेड इन COC ऑल्सो, है ना। तो सुप्रीम कोर्ट ने कहा कि नहीं, यू कैन नॉट बी इंक्लूडेड इन द COC ऑफ JP Infratech, है ना, और ये PUFE ट्रांजेक्शन है ना। बाकी तो हमने पहले भी डिस्कस कर लिया है इस केस को। So court held that the mortgage deed in question entered by JP Infratech to secure the debts of Jayaprakash Associates Limited obviously amount to creation of security interest in favor of Jayaprakash Associates Limited. It also noted that Jayaprakash Associates Limited was also the operational creditor of JIL and was providing financial, technical and strategic support. ठीक है। So the court concluded that JIL has given a preference by way of mortgage of preference transactions in question for the benefit of J. Prakash Associates for and on account of antecedent financial debt, operational debt and other liability. ठीक है, चलिए नेक्स्ट केस था हमारा स्विस रिबन्स प्राइवेट लिमिटेड वर्सेस यूनियन ऑफ इंडिया. सो दिस केस इन्वॉल्व ए कॉन्स्टिट्यूशनल चैलेंज. बहुत सारे प्रोविजंस को चैलेंज किया. क्या क्या चैलेंजेस थे? सबसे पहला तो चैलेंज था कि व्हाई देयर इज ए डिफरेंशिएशन बिटवीन फाइनेंशियल एंड ऑपरेशनल क्रेडिटर्स. कि भाई क्रेडिटर तो क्रेडिटर ही है, व्हाई यू आर डिफरेंशिएटिंग बिटवीन टू टाइप्स ऑफ फाइनेंशियल क्रेडिटर्स. तो द सुप्रीम कोर्ट upheld the classification, reasoning that financial creditors are typically involved in assessing the viability of a corporate debtor and are better equipped for the task. ठीक है, so they are the ones who have funded the company. The classification was held to be reasonable and not discriminatory under Article 14 of the Constitution. ठीक है. सेक्शन 12A, सेक्शन 12A को भी चैलेंज किया गया. It allows for withdrawal of insolvency proceedings with 90% approval from COC. The court emphasized that this provision promotes settlement and resolution, and the high threshold is to prevent misuse. ठीक है. थर्ड था रोल ऑफ आरपी इज एडमिनिस्ट्रेटिव. The RP does not adjudicate disputes, ठीक है, but only manages the process. Therefore, the appointment of an RP by the COC was found not to compromise independence. COC's powers are not arbitrary. The court found that the commercial decisions of the COC, they are based on the collective wisdom of the creditors and are not subject to judicial review, except on limited grounds. ठीक है, for example, if discriminatory or illegal. Another point was whether IBC is constitutionally valid. So the overall scheme of the IBC was found to be fair, non-arbitrary, and within the constitutional framework. The court has a legitimate aim, a resolution over liquidation, and is structured to promote economic revival. तो ये बहुत सारे इसके अंदर सुप्रीम कोर्ट की फाइंडिंग्स थी. इसमें बहुत सारी चीजों को चैलेंज किया था. So in the case of Swiss ribbons, the Supreme Court confirmed the IBC's constitutionality. नेक्स्ट केस था हमारा बाबूलाल वरदरजी गुर्जर वर्सेस वीर गुर्जर एल्यूमिनियम इंडस्ट्रीज. इस केस में भी लिमिटेशन पीरियड का इशू था. लिमिटेशन पीरियड 238A आ गया है बाद में 2018 में. तो इशू क्या था? तो दिस केस इन्वॉल्व्ड अ चैलेंज टू द इनिशिएशन ऑफ इंसॉल्वेंसी प्रोसीडिंग्स अंडर सेक्शन 7 बाय ए फाइनेंशियल क्रेडिटर. ठीक है. द अपेलेंट, ये कौन था? बाबूलाल वरदरजी गुर्जर. ही वाज द प्रोमोटर और सस्पेंडेड डायरेक्टर. ही कंटेस्टेड द प्रोसीडिंग्स primarily on the ground related to the limitation period and the maintainability of the application. उन्होंने कहा भाई सेक्शन 7 वाली एप्लीकेशन जो है मेंटेनेबल नहीं है. ठीक है. तो की इशू क्या थे? इशू ये था कि whether the section 7 application filed by the financial creditor was barred by limitation. ठीक है. Whether the CIRP could be initiated for debts that had become time barred, and applicability of Article 137 of the Limitation Act to RBC proceedings. ठीक है. फैक्ट्स क्या था? द कॉर्पोरेट डेटा वीर गुर्जर एल्यूमिनियम इंडस्ट्रीज प्राइवेट लिमिटेड, इट वाज एंगेज इन मैन्युफैक्चरिंग ऑफ एल्यूमिनियम एंड डायरेक्टर वाज बाबूलाल वरदरजी गुर्जर. ठीक है. एडजुडिकेटिंग अथॉरिटी एडमिट द एप्लीकेशन अंडर सेक्शन 7 and appellant preferred an appeal before NCLAT. NCLAT held that neither the application under section 7 is barred by limitation nor the claim of respondent number 2 is so barred and has therefore dismissed the appeal. Now the matter went to Supreme Court. So the discussion foregoing leads to the inescapable conclusion that the application made by the respondent number 2 under section 7 seeking initiation of CIRP with specific assertion of the date of default. अब उसने देखो कोर्ट क्या करता है? कोर्ट देखता है कि भाई आपने अपने आर्गुमेंट्स में क्या लिखा है. इन्होंने आर्गुमेंट में लिखा कि डेट ऑफ डिफॉल्ट जो है वो 8 जुलाई 2011 है. जब 8 जुलाई 2011 है तो नेचुरली इट इज बार्ड बाय लिमिटेशन, है ना. It is clearly barred by limitation for having been filed much later than the period of 3 years from the date of default as stated in the application. NCLT ने इस इशू को एग्जामिन नहीं किया और NCLT ने जो डिसीजन दिया वो कुछ और ही कंसिडरेशंस पर दिया. NCLT having decided the questions of limitation on entirely irrelevant considerations and the attempt on the part of the respondents to save the limitation with reference to the principles of acknowledgement having been found unsustainable, the impugned orders deserve to be set aside and the application filed by respondent number 2 deserves to be rejected as being barred by limitation. इन्होंने मेन आर्गुमेंट सुप्रीम कोर्ट का ये था कि भाई आपने डेट ऑफ डिफॉल्ट 8 जुलाई लिखी है, उसके अलावा आपने आर्गुमेंट कुछ लिया ही नहीं। एनसीएलटी में आप ये पॉइंट ही नहीं लाए लिमिटेशन वाला, एनसीएलटी में लिमिटेशन वाला पॉइंट लाए लेकिन और ही बातें करते रहे आप, है ना। तो उन्होंने कहा कि दिस एप्लीकेशन इज बार्ड बाय लिमिटेशन। So Supreme Court held that Section 7 application was filed beyond the limitation period without any valid extension through acknowledgement or part payment. Hence, it was barred by limitation and liable to be dismissed. ठीक है। तो mandated strict adherence to the 3-year limitation period for initiating insolvency proceedings, directed tribunals to suo motu consider limitation where applicable, and strengthened legal certainty for corporate debtors by disallowing stale claims from triggering insolvency. Next case था case Sasidhar versus Indian Overseas Bank. So this case arose under the IBC involving the rejection of a resolution plan by COC. The core question was whether the NCLT or NCLAT can interfere with the commercial wisdom of the COC when it rejects a resolution plan. Okay. The resolution plan in question was rejected by the COC even though it met the basic requirements. The promoter, K. Sasidhar, challenged the rejection, arguing that NCLT or NCLAT should have intervened and approved the plan. भाई देखो इसमें इशू क्या आ गया कि COC ने एक रेजोल्यूशन प्लान को रिजेक्ट कर दिया है, तो क्या एडजुडिकेटिंग अथॉरिटी उसको अप्रूव कर सकती है? ठीक है। अमेंडमेंट ये
सर
जो
एक
पहले,
क्वेश्चन।
हाँ जी अजय जी बोलिए।
सर इसमें के श्रीधर इज लाइक प्रमोटर कॉर्पोरेटर के डायरेक्टर,
हाँ हाँ प्रमोटर है ये, हाँ।
तो why he would challenge the rejection of the NCLT? उससे उनका क्या फायदा
भाई देखो अगर
एक्चुअली?
रिजेक्शन हो जाए तो लिक्विडेशन हो जाता है ना, एक्चुअली बात ये है।
ओके।
अमेंडमेंट इसमें क्या था कि पहले जो है ना लिमिट होती थी 75%, अभी तो 66% हो गया फॉर अप्रूवल ऑफ प्लान। सो अमेंडमेंट वाज मेड इन सेक्शन 30 सबसेक्शन 4 विद इफेक्ट फ्रॉम 6 जून 2018। अकॉर्डिंग टू द अमेंडमेंट, the requisite percentage for approval of resolution plan by COC, which was not less than 75%, was reduced to not less than 66%. हुआ क्या था कि 66% से ज्यादा वोट मिले थे इसको, लेकिन 75 से कम मिले थे। ठीक है, जब इन्होंने रिजेक्ट किया 75% मेजोरिटी नहीं मिली थी सीओसी में। बाद में ये अमेंडमेंट आ गई तो प्रमोटर ने कहा भाई देखो अब एडजुडिकेटिंग अथॉरिटी इसको अप्रूव कर दे प्लान को। पॉइंट ये था। तो whether the percentage of voting share is mandatory and what is the role of RP and whether the amendment is prospective or retrospective. Okay. According to the resolution applicant and stakeholders supporting the concerned resolution plan, the stipulation in section 30 subsection 4 as applicable at the relevant time in October 17 is only directory and not mandatory. This argument is founded on the expression may occurring in section 30 subsection 4. तो इसमें एक तो आर्गुमेंट ये दिया गया कि भाई ये जो परसेंटेज है ये डायरेक्टरी है, मैंडेटरी नहीं है। ठीक है, सुप्रीम कोर्ट ने कहा दिस आर्गुमेंट डज नॉट कमेंट टू अस इन दैट द वर्ड मे इज एस्क्राइबेबल टू द डिस्क्रिशन ऑफ द सीओसी टू अप्रूव द रेजोल्यूशन प्लान। अगर हम सेक्शन 30 सबसेक्शन 4 को देखें तो सेक्शन 30 सबसेक्शन 4 हमारा क्या कहता है? सेक्शन 30 सबसेक्शन 4 कहता है द कमिटी ऑफ क्रेडिटर्स मे अप्रूव ए रेजोल्यूशन प्लान। ठीक है, तो इन्होंने कहा कि भाई मे, सुप्रीम कोर्ट ने कहा कि मे का मतलब ये नहीं है कि मे बात जो है ये डिस्क्रिशन है 66% के लिए। ठीक है, इट इज ascribable टू द डिस्क्रिशन ऑफ द सीओसी टू अप्रूव और नॉट टू अप्रूव। What is significant is the second part of the said provision, which stipulates the requisite threshold of not less than 75. उस टाइम 75 होती थी। ठीक है, to treat the resolution plan as duly approved by the COC. That stipulation is the quintessence and made mandatory for approval of the resolution plan. Upon receipt of a rejected resolution plan, the A is not expected to do anything more, but is obliged to initiate liquidation process. उन्होंने कहा भाई अगर COC ने रिजेक्ट कर दिया तो हम अप्रूव नहीं कर सकते उसको। ठीक है, so SC held that COC is called upon to consider the resolution plan under section 30 subsection 4 after it is vetted and verified by the RP as being compliant with all the statutory requirements stipulated under section 30 subsection 2. The RP is not required to express his opinion on the matter within the domain of FCs to approve or reject the resolution plan. The Amendment Act will have prospective application and apply only to the decision of the COC taken on or after that date concerning the approval of plan. ठीक है, तो जो पहले वाला जो COC ने रिजेक्ट कर दिया क्योंकि 75% मेजोरिटी नहीं मिली, तो एडजुडिकेटिंग अथॉरिटी उसको अप्रूव नहीं कर सकती। नेक्स्ट केस था हमारा मनीष कुमार वर्सेस यूनियन ऑफ इंडिया। इस केस में क्या था, अब आपको मालूम है कि सेक्शन 7 सबसेक्शन 1 में एक प्रोवाइजो आ गया था, है ना, क्योंकि होम बार्स का शुरू से ही प्रॉब्लम चलता रहा। भाई बिल्डर लॉबी भी है ना। अब बिल्डर लॉबी कहती है भाई पहले तो 1 लाख रुपए की लिमिट थी ना, और एक होम बायर का भी अगर कोई डिस्प्यूट हुआ, 1 लाख रुपए का भी डिफॉल्ट हुआ, तो वो कंपनी को IBC में ले आता था। 12A भी नहीं था उस टाइम। तो इन्होंने यहां पर क्या कहा, इन्होंने कहा भाई मिनिमम इतने होने चाहिए, ऐसा नहीं कि एक आदमी को तकलीफ है तो पूरे प्रोजेक्ट को ही हाल्ट कर दो। फिर इसको चैलेंज किया गया। Amendment to Section 7(1) incorporated a proviso that allottees under a real estate project desirous of triggering the insolvency resolution process under the code are required to file an application jointly by not less than 100 of such allottees under the same real estate project, or not less than 10% of the total number of allottees under the same real estate project, whichever is less. ठीक है, moreover they should belong to the same project. ये था। Further, the petition sought to challenge another proviso amending section 7(1) of the code. इसमें एक और भी अमेंडमेंट आया था कि भाई जो एप्लीकेशन पहले से एडमिटेड है उसको भी 30 दिन के अंदर ये कर लो सही, अदरवाइज क्या होगा, दे विल बी डीम्ड टू बी विथड्रॉन। That those applications under section 7 which had not been admitted would stand withdrawn within 30 days if the newly declared minimum threshold of 100 allottees or 10% of the allottees, whichever is lower, was not garnered by the respective applicant. तो ये provisions को challenge किया गया इस केस। The petitioners have approached the Supreme Court under Article 32 of the Constitution of India. ठीक है, violation of fundamental rights. The petitioners contended that the second proviso to Section 7(1) of the code was unreasonable, arbitrary, irrational, ultra vires. It was contended that the amendments resulted in hostile discrimination between the petitioners and other financial creditors, lacking any intelligible differentiation. However, the SC, in what may be viewed as a blow to allottees of real estate project, has upheld the provisions amending Section 7(1) of the code. ठीक है, the SC further clarified that it does not matter whether a person has one or more allotments in the name of his family. ठीक है, all independent allotment would classify as separate allottees and would be counted for in the calculation of 100 allottees या 1/10 of the allottees. It was then clarified that in case of a joint allotment to more than one person, the allotment is to be treated as a single allotment. तो इसमें ये कहा it was held to be constitutionally valid, कि कोई दिक्कत नहीं। नेक्स्ट केस था P. Mohan Raj and others वर्सेस शाह ब्रदर्स इस्पात। इसमें क्या था, ये 138 वाला केस था एक्चुअली, कि as many as 51 checks were issued by the company in favor of the respondent towards amounts payable for the supplies, and they were all returned dishonored for the reason funds insufficient. The respondent issued a statutory demand notice under Section 138, read with Section 141 of the Negotiable Instruments Act, calling upon the company and its 3 directors, the appellants, to pay this amount within 15 days of the receipt of the notice. ठीक है, meanwhile, as a statutory notice under Section 8 had been issued by the respondent to the company, and an order was passed admitting the application under Section 9. ठीक है, now the question came whether the scope of Section 14 would cover the magnitude of the Negotiable Instruments Act. And is it permitted to initiate the check bounce proceedings under the Negotiable Instruments Act, or to continue the proceeding against the CD and its directors when the CD is about to resolve its bankruptcy issue or in an ongoing CIRP? So Supreme Court said that Section 138 or 141 of the Negotiable Instruments Act proceeding against a corporate debtor, it is also covered by Section 14(1)(a). ठीक है, and moratorium provision contained in Section 14 would apply only to the corporate debtor. The natural persons mentioned in Section 141 continuing to be statutorily liable under Chapter 17 of the Negotiable Instruments Act. उन्होंने कहा proceedings can go on against the natural person. कॉर्पोरेट पर्सन्स के अगेंस्ट में 14 लग जाएगा, लेकिन सेक्शन 14 वुड नॉट ऑपरेट अगेंस्ट द नेचुरल पर्सन्स। ठीक है, तो आप जो डायरेक्टर्स है जिन्होंने चेक साइन किया उसके अगेंस्ट में प्रोसीडिंग चला सकते हो, कोई दिक्कत नहीं। ये इशू था। गुजरात ऊर्जा विकास निगम लिमिटेड वर्सेस अमित गुप्ता एंड अदर्स। सुधाकर जी आप पढ़िए जरा इस केस को एक बारी, आपके पास है ना ये? सुधाकर जी आर यू देयर?
यस सर, सर मैं हूँ सर। यू वांट मी टू रीड इट सर?
हाँ यस यस, ब्रीफ फैक्ट्स
यस सर।
पढ़िए।
Gujarat Urja Vikas Nigam Limited versus Mr. Amit Gupta and others.
Hmm.
Brief facts. A PPA entered between
पावर परचेज एग्रीमेंट एक्चुअली,
yes, sir, power purchase agreement. Yes, sir. A PPA entered between Gujarat Urja Vikas Nigam Limited and Aston Field Solar Gujarat Private Limited, probably a solar power developer, corporate data. The PPA was entered on 30th April 2010 in accordance with GUVNL was to purchase all the power generated by the solar power plant. Future, it will be read as plant of the CD for the term of PPA, that is for 25 years. Due to persistent default by CD in fulfilling its contractual obligation arising out of financial documents, on 4th May 2018, lenders declared CD to be a non-performing asset. Post declaration of NPA, CD filed a petition before the NCLT under Section 10 of IBC to initiate the CIRP. The said petition was admitted on 20th November 2018 and the RP was appointed by the NCLT in February 2019. 3. GUVL issue notices of default on 1st May 2019 to corporate debtor. Corporate debtor undergoing CIRP under insolvency and bankruptcy code 2016 amounts to an event of default under PPA. Default notice specifically stated that the PPA will be terminated if the CD does not cure the defaults mentioned in the default notice. The termination notice was stayed by the NCLT by its order dated 29th August 2019. NCLT held that the clauses of the PPA cannot be placed on a higher pedestal than the provisions of IBC. PPA is an instrument within the meaning of Section 238 of IBC, and in the present case, the clauses of the PPA are inconsistent with the provisions of IBC. NCLAT also held that GUVNL attempted to terminate the PPA on the sole ground that the CIRP has been initiated against the CD. It was observed that during the CIRP, the RP has to maintain the CD as a going concern, and termination of the PPA would render the corporate debtor defunct. Honorable Supreme Court, while affirming order of the NCLAT, dwelled upon the following issues. The Apex Court observed that the IBC contemplated the establishment of single forum in order to deal with the matters of insolvency which were distributed. Sir, which were distributed earlier across multiple fora. The Apex Court placed reliance on ArcelorMittal India Private Limited versus Satish Kumar Gupta 2019 to SSU 1. Observed that the NCLT alone has jurisdiction when it comes to applications and proceedings by or against a corporate debtor covered by the code, and no other forum has jurisdiction to entertain or dispose of such applications or proceedings which arise solely from or which relate to the insolvency of the CD. In the instant matter, PPA was threatened to be terminated solely on the ground of insolvency. In the absence of the insolvency of the CD, there is no ground to terminate the PPA. The Honorable Court recognized that Section 86(1)(f) of the Electricity Act empowers GERC to adjudicate dispute between generating company and the distribution licensee. However, NCLT will have the power to adjudicate the present dispute under Section 65C of the IBC because the sole default attributed to GUVNL to the corporate debtor was that it was undergoing an insolvency resolution process. The Honorable Court further held that Section 238 of the IBC stipulates that IBC would override other laws, including an instrument having effect by virtue of any such law. The NCLT correctly stated the termination of the PPA by the appellant, since allowing it to terminate the PPA would certainly result in the corporate death of the corporate debtor due to the PPA being in its sole contract.
So the issue here was, the main issue was that this Gujarat Urja Vikas Nigam Limited, they sought to terminate the power purchase agreement because they said that you have filed an application under Section 10 and it is a default. So we are terminating this power purchase agreement. But Supreme Court said that, okay, if this power purchase agreement is terminated, then who will buy this company? है ना? So it would render the corporate debt a defunct. है ना? It would result in corporate death. So they said that if there is any other ground to terminate, then it is okay. But simply on the ground of insolvency, you are terminating this power purchase agreement, so it is not in order. That was the main point. Next case is Arun Kumar Jagaratmaka versus
हाँ.
Jindal Steel. So the point,
Jindal Steel
yes,
Power. Yeah, मैं
हाँ.
पढ़ लेता हूँ सर.
पढ़िए, please.
Brief facts. When the judgment was rendered in an appeal filed by Jindal Steel and Power Limited, an unsecured creditor of the corporate debtor, Gujarat NRE Coke Limited, GNCL. The appeal was preferred against an order passed by the NCLT in an application under Section 230 to 232 of the Act of 2013. This is Company Act, no sir? Act of
Yes,
2000.
yes. हाँ.
Preferred by
इसको मैं लिख देता हूँ of the Companies Act.
Companies Act, sir.
Companies, yes.
Act of
Yes,
2000.
2013
2013, preferred by Mr. Arun Kumar Jagaratmaka, who is the promoter of GNCL. National Company Law, NCLAT held that a person who is ineligible under Section 29A of the IBC to submit a resolution is also barred from proposing a scheme of compromise and arrangement under Section 230 of the Companies Act 2013. Honorable Supreme Court in Swiss Cement Private Limited versus another versus Union of India and others writ petition civil number 99/2000 held that the primary focus of the legislation is to ensure revival and continuation of the corporate debtor by protecting the CD from its own management and from a corporate death by liquidation. Issue 1. Whether in a liquidation proceeding under IBC, the scheme for compromise and arrangement can be made in terms of Section 230 to 232 of the Companies Act 2013. If so permissible, whether the promoter is eligible to file an application for compromise and arrangement while he is ineligible under Section 29A of the INB to submit a resolution. INB मतलब sir?
वो IBC कर देते हैं इसको. Insolvency and Bankruptcy Code.
Sir.
IBC कर दिया.
ठीक है sir. 29A of the IBC to submit a resolution plan, decision. As far as whether the scheme for compromise arrangement can be made, they said yes, as per provisions within 90 days. And with regarding to if permissible, is eligible to file application, though is ineligible under Section 29A. Prohibition placed by the Parliament in Section 29A and Section 35(1)(f) of the IBC must also attach itself to a scheme of compromise or arrangement under Section 230 of the Act of 2013. Sir, Companies Act कर दीजिए sir. When the company is undergoing liquidation under the auspices of the IBC.
So the main issue here was that if a person is ineligible.
दोनों को हाँ कह दिया sir.
हाँ. तो इन्होंने बोला कि भाई ठीक है, अगर if somebody is ineligible under 29A, so he cannot propose a scheme of compromise or arrangement also, है ना. और liquidation में भी बाहर है ना. If we see section 35(1)(f) also, तो 35(1)(f) क्या बोलता है? 35(1)(f) बोलता है सेल, है ना. ये प्रोवाइजो है 35(1)(f) का प्रोवाइजो. Provided that the liquidator shall not sell the immovable and movable property or actionable claims of the CD in liquidation to any person who is not eligible to be a resolution applicant, है ना. तो 35(1)(f) भी है. प्रोवाइजो हम लिख सकते हैं इसको, एंड प्रोवाइजो इसको हम कर देते हैं प्रोवाइजो टू एंड प्रोवाइजो टू सेक्शन 35. ठीक है, तो ये था. नेक्स्ट देखिए, Lakshmipad Surana versus
Union Bank of India and another. Background. The case concerns whether proceedings under Section 7 of the IBC can be initiated against a guarantor, not the principal borrower, especially when the principal borrower is not a corporate person but a guarantor is. In this case,
ये था कि principal borrower is a proprietorship concern और जो guarantor है that is a company.
ठीक है सर. Union Bank of India filed an application under Section 7 against Lakshmipad Surana, a corporate guarantor, for the loan granted to Mahavir Construction, a sole proprietorship, non-corporate entity. Key legal issues. Can a financial creditor initiate insolvency proceedings against a corporate guarantor under Section 7 of the IBC if the principal borrower is not a corporate person? From when is the limitation period to be calculated for initiating proceedings under IBC in such cases? Facts. Bank extended the credit facility to Ms. Mahavir Construction, a proprietary firm of the appellant, through two loan agreements in years 2007 and 2008 for a term loan of 9.63 crores and a further amount of 2.45 crores respectively. The loan amount was disbursed to the principal borrower. Mr. Surana Metals Limited had offered guarantee to the two loan accounts of the principal borrower. The stated loan accounts were declared NPA on 31/2010. The financial creditor then filed an application under Section 19 of the Recovery of Debts to Banks and Financial Institutions 1993 under the principal borrower against the principal borrower before the DRT at Kolkata. This application came to be resisted on diverse counts and specifically on the preliminary count that it is absolutely and was not maintainable because the principal borrower wasn't a corporate person, and further it had been barred by limitation because the date of default was 31/2010, whereas the application had been filed on 13/2/2019, that is beyond the period of 3 years. Significance. This judgment clarified that corporate guarantors are independently liable under IBC even if the principal borrower is not a company. Financial creditors have the right to initiate CIRP against guarantors without first proceeding against the principal borrower. Strengthen creditors' hands in enforcing guarantees through insolvency. Reinforce the doctrine of coextensive liability of guarantors.
तो ये था नेक्स्ट देख लीजिए.
ठीक है सर. Ghanshyam Mishra and Sons Private Limited through authorized signatory versus Edelweiss Asset Reconstruction Company. Background. This case clarified the finality and binding nature of an approved resolution plan under the insolvent IBC to the IBC. It focused particularly on the effect of Section 31(1) of the IBC and the 2019 amendment that added an explanation to it. The dispute arose because some creditors attempted to pursue claims against the CD even after the resolution plan was approved, arguing that their dues were still recoverable. Key issues. All our claims, including statutory dues like taxes, extinguish once a resolution plan is approved under Section 31(1) of IBC. Can any creditor, including government departments, continue to pursue claims not part of the resolution plan? Decision. The Supreme Court held that no creditor, including government authorities, can initiate or continue proceedings for claims not part of the approved resolution plan. All such claims stand extinguished once the plan is approved.
इसमें इशू क्या था? जो सेक्शन 31(1) है ना, उसमें it sought to clarify. This amendment was inserted in 2019. क्या बोला था? Including the central government, that if the adjudicating authority is satisfied that the resolution plan is approved by the COC meets the requirements, it shall by order approve the resolution plan, which shall be binding on the corporate debtor and its employees, members, creditors, including the central government, any state government or any local authority. So this was inserted regarding the central government, state government. ये इंसर्ट किया गया था आपका 2019 में. Why this was inserted? Because government authorities were of the view कि भाई हमारे ऊपर तो ये resolution plan नहीं चलेगा, हमारी liability तो separate है ना? We can still claim even after the approval of the resolution plan. तो इसमें 31(1) में clarification आया 2019 में. क्या बोला? It is equally binding on the central government, state government or any local authority. 31(1) if you see, so it contains this explanation. Yes, please. Yes, Sudhakar ji.
Yes, sir. Yeah. In Ghanshyam, Supra and other similar matters, various tax authorities and government departments pressed their claims against the CD even after the resolution plan was approved by the adjudicating authority. A major issue was raised in relation to the claims that did not form part of the resolution plan. It was argued that such claims be permitted to be enforced even after the resolution plan was approved. In the matter of one of the connected matters, Edelweiss Asset ARC versus Orissa Manganese and Minerals Limited and others, the Honorable NCLAT, while dismissing the appeal, left it open for these creditors to press their claims before a civil court or appropriate forum. The Honorable SC has
इस केस में क्या हुआ था? इस केस में एनसीएलटी ने कहा यहाँ पर तो नहीं है, लेकिन आप सिविल कोर्ट में जा सकते हो. तो
ठीक है,
सुप्रीम कोर्ट ने कहा सिविल कोर्ट में भी नहीं जा सकते once a
Yes,
resolution
sir.
plan is approved.
NCLT, set aside the NCLT's findings and reiterate the law laid down in COC of SR Steel India Limited through authorized signatory versus Satish Kumar Gupta and others, wherein the SC categorically held that once the resolution plan is approved, all claims stand extinguished and the CD is handed over to the resolution applicant as a fresh slate. Significance. This ruling gives certainty and finality to resolution plans, encourages resolution applicants by protecting them from past liabilities, strengthens the clean slate doctrine, which is critical to effective corporate rescue, clarifies that statutory dues are not immune from discharge under IBC.
तो ये नेक्स्ट देख लीजिए.
Yes, sir. Pratap Technocrat Private Limited and others versus monitoring
आज
committee.
20 केस लॉस कर लेंगे हमें ना. 20 तो कर ही लेते हैं कम से कम. 2
हाँ,
केस
ठीक.
लॉ और कर लेते हैं. हाँ जी.
ठीक है, sir. Factual matrix. CARP under the IBC was commenced under against Reliance Infratel Limited, wide order dated 15 May 2018 by the NCLT. Pursuant to such order, an IRP was appointed and COC was formed on 24th May 2019. After due deliberation between the COC and the prospective resolution applicants, the plan submitted by Reliance Digital Platform and Project Services Limited, successful resolution applicant SRA, was approved by the COC with 100% vote on 2nd March 2020 on the basis of its feasibility, viability, and implementability. An appeal was filed under Section 62 of IBC by Pratap Technocrats and others appellants who are operational creditors of the corporate debtor before NCLT on the ground of unfair and inequitable treatment of OCs and material irregularities in accumulation disbursal of funds. It was also argued that there was a haircut of 90%. Furthermore, it was contended that the CARP in itself was conducted in a secluded manner and the OCs were not made aware of the ongoing process. The appellant herein claimed that it has 90% of total operational debt and is small and medium-sized company who has not been given due regard by the COC. The application filed by Doha Bank 1 of FC was also brought at the stage of submissions to raise the contention that many FCs were excluded from the COC. It was contended that the NCLT failed to consider the implication of such exclusion of FCs in the COC and that such exclusion resulted in increasing the rate of recovery for the FCs from 10.32% to 91.98%. Yes, sir, yeah. Yes, sir. Rate of recovery has increased.
Actually, sometimes suppose certain financial creditors are not included. So then the proportion will change. That is the point.
Right, right, sir. Right, sir. A contention was raised by the appellant that the realizable value of preference shares held by the wholly owned subsidiary of the CD, namely Reliance Bhutan Limited in Reliance Realty Limited, was excluded from the liquidation value. It is pertinent to note that these preference shares were to be segregated and reserved for realizing rupees 800 crore for FCs as per the appellant's submissions. The Apex Court, however, noted that this was factually incorrect on the basis of the valuation report submitted by the appointed valuers. Apex Court verdict. On the application filed by Doha Bank, it was held that such application has no bearing on the present matter and rejected any contention raised with respect to the same. For the issue on jurisdiction of approval of RP resolution plan, the Apex Court once again upheld the wisdom of COC and held that once the AA is satisfied that the resolution plan has been approved in compliance with the provision of IBC and majority vote of COC, the AA shall mandatorily cease its jurisdiction. Focusing on the powers and functions of the AA under IBC, it was noted that it is a creature of statute and it required to function within the realms of such statute only. In the end, the Apex Court upheld the COC wisdom who approved the plan with 100% vote in the present case and noted that the AA is confined to the discipline and boundary of the statute and is only required to ascertain if a resolution plan meets the criterion under the IBC. Therefore, the appeal was dismissed.
ये अपील की थी ओसी ने. भाई ओसी का तो वैसे कोई राइट नहीं है.
Apex Private Limited versus Committee of Creditors of Educom Solutions Limited and another. Background. Apex Singapore submitted a resolution plan for Educom Solutions Limited, which was approved by the COC and then submitted to the NCLT for approval under Section 31 of the Insolvency IBC. Before the NCLT could approve the plan, Apex sought to withdraw or modify the resolution plan, citing post-submission developments and alleged separation material facts by the CD. This raises a fundamental question. Can a resolution application with applicant withdraw or modify the resolution plan after it has been submitted to the NCLT for approval, but before it is approved? Key legal issues. Whether a resolution applicant has the right to withdraw or modify a resolution plan after submission to the NCLT under Section 31 of the IBC. What is the scope of judicial discretion under Section 31 in such scenarios? Whether NCLT has power to allow withdrawal of resolution plan submitted for approval after approval of COC, and COC rejected withdrawal application. The NCLT had allowed the application filed by EBIX under Section 65 of the Code to withdraw the resolution plan submitted by it for EDUCOM. While reversing that order, NCLAT held that the application seeking to withdraw from the resolution plan could not have been allowed. Supreme Court's observation, Supreme Court considered the correctness of the aforesaid order of NCLAT. It was inter alia held and observed as under decision. The court rejected EBIC Singapore request to withdraw its resolution plan. It held that resolution application have no right to withdraw or seek modification once the plan is submitted to the AA. Conclusion. The above stated observation of Supreme Court in EBIC affirmed the findings of NCLAT. The resolution plan approved by the COC cannot be allowed to be withdrawn or modified by the successful RP by approaching the adjudicating authority.
इसमें एक्चुअली हुआ क्या था कि ना इट वाज ए वो पेंडेमिक पीरियड वाला है ये, तो पेंडेमिक पीरियड में एडजुडिकेटिंग अथॉरिटी दे आल्सो टुक सो मच टाइम इन डिसाइडिंग ऑन द एप्लीकेशन। तो इसने बोला भाई मेरा तो प्लान ही अनवायबल हो गया है ना, ये पेंडेमिक वगैरह आ गया था, इनका ऑनलाइन कोचिंग वगैरह का कोई सिस्टम था, तो इन्होंने कहा वी वांट टू विड्रॉ द रेजोल्यूशन प्लान। बट सुप्रीम कोर्ट ने कहा भाई इस तरह से अगर हम विड्रॉ अलाउ करेंगे, सीओसी ने अप्रूव कर दिया है, द मैटर इज पेंडिंग बिफोर ए। उन्होंने ए को भी बोला कि भाई ए को भी जल्दी डिसीजन लेना चाहिए, ऐसा नहीं कि भाई सालों साल उनके पास रेजोल्यूशन प्लान पेंडिंग पड़ा रहे, ये भी था इसमें। बट अल्टीमेटली द सुप्रीम कोर्ट सेड दैट वंस ए रेजोल्यूशन प्लान हैज बीन सबमिटेड फॉर अप्रूवल इट कैन नॉट बी विथड्रॉन एट दिस स्टेज। ठीक है जी, तो वी वर एबल टू डू 20 और बाकी वाले फिर देख लेते हैं, नेक्स्ट क्लास में देख लेंगे, है ना। एंड आई विल अगेन शेयर दिस पीपीटी विद यू, है ना। तो चलो कुछ तो हो गया ना, धीरे धीरे ऐसे
सर न्यू सिलेबस में कितना कितना केस लॉ आया?
क्या चीज?
न्यू सिलेबस में कितना
72।
अच्छा 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 अच्छा।
हाँ, बट ऐसा है पुराने वाले तो सारे ही है तकरीबन, नए ही ऐड कर दिए उन्होंने, पुराने में कोई घटाया नहीं ज्यादा।
और ये सुप्रीम कोर्ट में कितना केस लॉ है अभी?
सुप्रीम कोर्ट ये मैं पीपीटी शेयर कर दूंगा ना ग्रुप में, मैं पीपीटी शेयर कर दूंगा। हाँ, मेरे ख्याल काफी है सुप्रीम कोर्ट का।
सुप्रीम कोर्ट तो ओल्ड सिलेबस में 31 था।
हाँ 31, अब ये तो 40 से ऊपर हो गए इनके, 42 हो गए, 41 हो गए।
पुराना केस लॉ सभी है।
हाँ
सुप्रीम कोर्ट केसेस ज्यादा ऐड कर रहा सर।
हाँ हाँ हाँ। भाई एक्चुअली वो सोच रहे हैं यार ज्यादा काम तो है नहीं आईपी के पास, इसलिए कम कम लोग पास करो। लेकिन आगे आगे ठीक हो जाएगा, ऐसी बात नहीं, ये भी काम देखो थोड़ा सा स्ट्रगल तो है, लेकिन आगे आगे देखो बेटर ही होगा, ऐसी कोई बात नहीं। मेरे को लगता है कि 1-2 साल में और ठीक हो जाएगा, तो जो लोग एंटर कर लेंगे ना स्टेज पे वो बढ़िया रहेंगे, कोई दिक्कत नहीं रहेगा उनको।
Sir, for an act, I mean, 2016 मतलब 9 years is a small period, sir.
हाँ और क्या, बिल्कुल ठीक बात।
क्योंकि इवोल्यूशन
2016 में भी तो एंड में आया, दिसंबर में आया था ये।
हाँ, yes sir.
तो 2017 से ही समझो 2016 में
which means hardly 8 years.
हाँ और क्या, बिल्कुल ठीक बात है।
And moreover, evolution में ups and downs होता।
हाँ और क्या, ये तो है।
बट लो हैंगिंग फ्रूट ज्यादा है सर। आई मीन टॉप लेवल में अभी वो खत्म हो गया, बिकॉज द अर्लियर आरपीस हैव मिसयूज्ड a lot of provisions. So now I mean everything ठीक कर दिया, बट लो हैंगिंग फ्रूट ज्यादा है सर।
नहीं अभी तो जो अमेंडमेंट आया है, अमेंडमेंट इन रेगुलेशंस आल्सो।
आई एम लीविंग एक्चुअली।
ओके,
कंटिन्यू।
ठीक है।